Well, hello, and welcome back to Smart Financial Future. I'm John Williams, Certified Financial Planner and Senior Advisor at Ironwood Wealth Management. Today, I want to go over how assets pass on after you pass away. Did you know the law provides each of us with the right to own property since we're alive? However, if you're not alive, you don't have property rights. You know, after you pass away, your property has to transfer to someone else or to an entity. So who has the authority to decide who is entitled to our property and to transfer it? Why don't we take a look at how assets transfer after you pass away? Typically, there are two ways assets pass at death. The first is through a court, and the other is out of a court. Some assets, by their very nature, are what I'm going to call out-of-court assets. For example, when someone is designated as your beneficiary on your life insurance, that beneficiary collects the money upon your death without it going through a court proceeding. The insurance company simply pays whoever your beneficiary is. I want to take a quick second to mention at this point, you can change an in-court transfer to an out-of-court transfer by how it's titled. A good example I can come up with is when you set up the title to real estate as joint tenants with rights of survivorship. That means at the death of the first owner, the surviving owner receives the entire real estate interest without it going through a court proceeding. Assets that transfer through the court after your death are also known as probate assets. Very simply, probate is just the court process of deciding what goes where. If you die with a valid will, that is also known as testate. Your will generally guides the probate process, you see. On the other hand, if you die without a valid will, that is called intestate. When that happens, the court will use the law and its judgment to decide who gets what. In general, if an asset isn't the out-of-court type, it must pass through the probate process. So let's talk about what I'm going to call out-of-court assets, or sometimes non-probate assets. And it's exactly what it sounds like. They are the assets that pass outside the court system. Many times, out-of-court transfers occur by a contract of some kind, such as life insurance, or an IRA, or a retirement plan, or an annuity. That would even include assets that are held jointly with rights of survivorship. In those cases, your beneficiaries will receive those out-of-court assets directly. Let's say for a minute, just to give you an example, I had listed my son as beneficiary on my IRA, but somehow I had listed my daughter as the beneficiary in my will. In that case, who do you think gets the money from the IRA if something happens to me? Well, the answer in this case is it would be my son. With assets that pass via a contract, whoever is listed as beneficiary on that contract will receive the assets regardless of what the will says. Another type of out-of-court asset are those that are held by irrevocable, or sometimes you'll hear people say irrevocable, trusts. These assets don't go through probate because you don't own them. The trust actually does. When you die, only the assets you own directly are included in your probate estate. Since assets in an irrevocable trust don't technically belong to you, they are not included in your probate. After your death, the trust merely follows your instructions about who gets what and when they're supposed to get it. So if it makes sense, you can put some or all of your assets in a trust before you die, which turns assets that would have passed through the court system into out-of-court type assets. This has been John Williams with the financial educational blog site, Smart Financial Future. Don't hesitate to let us know if you have any questions, and we hope to see you next time.